Under section 132, witness not to be excused from answering on a ground that answer will criminate. Under this section, a witness is not excused from answering any questions relevant to the matter in issue on the ground that the answer to such question may criminate him or expose him to a penalty or forfeiture. The section does not in turn deal with all criminatory questions which may be addressed to a witness, but only with the questions as to a matter relevant to the matter in issue. Irrelevant questions should not be allowed, and it may be implied from the limitation in this section that a witness should be excused from answering questions tending to criminate as to a matter which are irrelevant. A witness who answers a question or a questions put to him by counsel without seeking the protection of this section is not entitled to that protection. The section makes a distinction between those cases in which a witness voluntarily answers a question and those in which he is compelled to answer, and give him a protection in the latter of these cases only. Protection is afforded only to answer which a witness has objected to give or which he has asked to be excused from giving, and which then he has been compelled by a court to give. In the case of Mohar versus Queen Empress, 1893, 21 Calcutta, 392, it was held that the mere summoning of a witness or ordering him to go to the witness box does not compel him to give any particular answer or to answer any particular question. The word shall be compelled to give in the proviso apply to pressure put upon a witness after he is in the box, and when he asks to be excused from answering question. 133. Accomplice. The evidence of an accomplice, though it is uncorroborated, may be from the basis for a conviction. This section is the only absolute rule of a law as regards the evidence of an accomplice. But illustration B to the section 114 is a rule of guidance to which also the court should have regard. It is, however, not a hard and fast presumption, incapable of rebuttal. Presumption juris ita jure. The combined effect of this section and section 114, illustration B, is that though the conviction of an accused on the testimony of an accomplice can be said to be illegal, yet the courts will, as a matter of practice, not accept the evidence of such witness without corroboration in a material particulars. It has been suggested that it ought to be normal practice for the previous conviction of an accomplice giving evidence to be disclosed to the Crown at the outset. The court said that if any accomplice witness with a heavy criminal record was protected against the disclosure of such record, then as against the Crown witnesses, such witnesses be enjoying too much such freedom. It is the invariable practice of the court to require the corroboration by an independent witnesses of so much of the evidence of an accomplice as goes to identify the accused person as the offender. Such corroboration ought to be that which is derived from unimpeachable or independent evidence. It would be risky to base conviction on the sole retracted statement of the co-accused, but conviction is not barred. Section 32, subsection 1 of the Criminal Justice and Public Order Act 1994 has abrogated the rule requiring compulsory warning for the corroboration of the evidence accomplices and complainants in sexual cases. The Law Commission proposals mark the culmination of a growing dissatisfaction among the judges, practitioners, and academic commentators at the complex and inflexible nature of the warning and its tendency to confuse rather than assist the jury in its deliberations. Section 134, Number of Witnesses. Under this Act, no particular number of witnesses is required in any case. Of course, it is open to a final court of a fact to believe or disbelieve a statement, but simply because the statement is of the one witness, that cannot by itself be ground for not acting upon that testimony. Neither the number of witnesses nor the quantity of evidence is material. It is a quality that matters. There is a general public reluctance in appearing as a witness. Hence, there should be no insistence that there should be more than witness than one. The court said, the publics are generally reluctant to come forward to depose before the court. It is therefore not correct to reject the prosecution version only on the ground that all witnesses to the occurrence have not been examined. Nor is it proper to reject the case for want of corroboration by independent witness, if the case made out otherwise true and acceptable. The Supreme Court has been sustaining conviction on the basis of the testimony of a sole witnesses. In one of the case, it is remarked there is no computerized rule, nor are the judges computers. It must always depend on the circumstances of each case and the quality of the evidence of the single witnesses. In this case, we find there is abundant evidence, direct and circumstantial, to prove the guilt of appellant. The trial court called the appellant daredevil of the locality. No one was willing to come forward to depose against them. In such circumstances, as always, the court has to separate the grain from the chaff. The Supreme Court, in a Marwadi Kishore Paramananda case versus State of Gujarat, explained the reliability of factors in following words. Generally speaking, oral testimony may be classified into three categories, namely wholly reliable, wholly unreliable, and neither wholly reliable nor wholly unreliable. So far as the first category of the proof is concerned, the court had no difficulty in coming to its conclusion either way, that is to say, it may convict or may acquit an accused on the testimony of a single witness. If his testimony is found to be above the approach or suspicion, interdependence, incompetence, or subordination, in such cases of a second category of a witness, the court has equally no difficulty in putting to the conclusion. But in a third category of a case, the court has to circumspect and has to look for a corroboration in material particulars by reliability of a testimony, direct or circumstantial. More often, than not, there are situations where only a single person is available to give evidence in respect of a disputed fact. Naturally, in such situation, the court has to wait carefully such testimony, and if it is satisfied that the evidence is reliable and free from all taints which tend to render oral testimony to open a suspicion, it becomes a duty to act upon such testimony.